What damages are recoverable in Indiana for the wrongful death of a loved one? Indiana law provides by statute what can be recovered for the loss of a loved one. I can think of no greater loss to a family than the loss to a parent, child, or grandparent. In Indiana, the wrongful death statute clearly states that if a parent dies leaving a surviving spouse and or dependent minor children, or dependent children based upon the need for guardianship or disability, they're allowed to include in the claim made by the personal representative the following items. First, the medical and hospital bills that are incurred prior to death. Second, the funeral and burial expenses that are incurred. Third, the loss of earnings of the decedent. The loss of earnings are calculated to the date of the expected retirement. There can also be added to that a claim for the loss of benefits that would have been provided by Social Security had they worked until their normal retirement age. Finally, and most importantly, Indiana law includes in the claim, both to the surviving spouse and dependent children, the loss of love, society, and companionship that was lost as a result of the wrongful death. These elements of damage combine the basis for what can be recovered by the personal representative seeking to either settle the claim out of court or, if necessary, to file a lawsuit to seek a recovery for you.
What happens in those instances when an unmarried adult leaving no dependent has lost his or her life because of someone else's negligence? Can family members make a recovery? Yes, they can if those family members can prove that they have an ongoing relationship with the decedent. That is to show that it was a genuine, substantial, and ongoing relationship. You can then make that claim. That claim is for the medical bills, it's for funeral bills, it's for burial bills, and it's also for hospital bills. But no claim can be made for any loss of income in that instances. The statute is very specific, however, that the claim cannot be more than $300,000. It's capped. There can be no recovery more than that. But in those instances where a relative has lost his life or her life because of someone else's negligence, even though they have no children and they are not married, a recovery can be made if those elements are shown.
The wrongful death statute also sets out what type of recovery can be made for the wrongful death of a child. What constitutes a child by definition under the statute needs to be understood. First and foremost, a child is defined as someone under the age of 20 or under the age of 23 if they're in college or a technical school or a work-study type program. So if in fact they're unmarried and they're children under 20 or 23 and enrolled in college or work-study technical program, you are allowed to make a claim for the wrongful death of that child. It is the father and mother who make this claim. The law provides that they can claim the loss of the child's services as well as the loss of the love and companionship of the child. The medical and hospital expenses that are incurred, funeral and burial expenses, as well as any psychiatric or psychological counseling expenses that may be incurred and necessary for helpful recovery as a result of the death. The statute also says that the uninsured debts of the child can be included in the claim. All of these constitute elements of damage. I would ask that you consult with an attorney about the specific value of the case and how that value is arrived at.